Welcome everybody, thank you for joining us. This is the Chancery and Commercial Team's Law with Lunch. Ordinarily, we'd love to do this in person and actually eat lunch with you. Because it's the school holidays, and being a mother myself, I thought that the remote option might appeal to some more people. And actually, given the weather, I think that's probably been the right decision. So today, Adam and I are going to be looking at some of the common issues arising out of the Trust of Land and Appointment of Trustees Act 1996. Please feel free to eat some lunch while we're talking. After all, it is law with lunch. And if you'd like to join us by sharing your screen, that would be lovely too, but please don't feel obliged to. For those of you I haven't met, I'm Anna Metcalfe. I'm a barrister of 14 years call, and I specialise in wills and trusts litigation. My colleague Adam Gould, he specialises and practices in the full breadth of business and property work. So I'm going to be speaking first, and I am going to be looking at a refresher on two issues that I do crop up when advising on this sort of work. And firstly, whether or not it makes a difference whether there's been an express declaration of trust and how that interplays with the court's jurisdiction to find a constructive trust. So can further discussions or agreement ever change how property is owned where there's been an express declaration of trust? And then briefly, I'm going to look at how the court approaches applications for orders for sale under section 14. So I'm going to move on to my first slide now, Adam. How do I do that? Just click?
I think so, yeah.
That hasn't worked. You show me how to do it once, I should be able to do it next time.
Right now.
Lovely. So today's focus, already been through that. So express declarations of trust. So where are we looking to find our express declaration of trust? So what we're looking for is to see whether the legal owners of the property have actually declared how they own the beneficial interests. And this can be either at the date of purchase or at a later date. And we're looking for an express trust. If you've got unregistered land, which, believe me, does exist still, surprisingly, you need to look at your conveyance. And the wording that you're looking for is something along the lines of: the purchasers hold the property on trust for themselves as beneficial joint tenants, or on trust for themselves as tenants in common in equal shares or in unequal shares as follows. So that's the sort of wording you're looking for, and that will be your express declaration of trust. In respect of registered land, some of the old form registrations, some of the old office copy entries, sorry, not the old office copies entries. If you're looking at your office copy entries, what you need to look for is a Form A restriction. So that's the restriction that says no disposition by a sole proprietor of the registered estate under which capital money arises is to be registered unless authorised by the court. So that's your Form A restriction. Now that isn't an express declaration of trust, but what it does do is give you an indication that there has been an express declaration of trust. Because if the legal owner also owned the beneficial title fully, there'd be no need for that restriction. So that gives you your indication to look elsewhere for your express declaration of trust. Something that you might also see, and this is where I was referring to those old forms of the office copies entries, something you might see is a receipt clause. Now that will say something like, the survivor of the purchaser can give valid receipt for capital money. So it's quite old-fashioned wording. Now, previous cases have held that that amounts to an express declaration of trust, but the modern view is that that is not the case. So the leading case of Stack and Dowden from 2007 confirmed that those sorts of receipt clauses are really only worth anything where the parties have been advised about what they mean and what the consequences of their inclusion. Nowadays, it's quite rare to see those sorts of receipt clauses put into transfers. Something that you may be familiar with is the form TR1. So that's your transfer form when you're transferring property. And since 1998, there's been a box on that form, box 10, which is headed Declaration of Trust. Now, any competent conveyancer should make sure that that form is filled in. I'm sure we've all had experience of many incompetent conveyancers. So often that form is left blank, which does leave things in the air slightly. But if that box has been ticked, and it will say something, there's three options there. And one of them is that it's held as tenants in common in equal shares. One of them is that it's a joint tenancy. And one of them is it's held on some other trust. The details are below. So you would hope to see one of those three boxes ticked. If it is ticked, then that is an express declaration of trust. Of course, you can have an express declaration of trust which exists aside from the transfer, so just a standard trust document. And that's quite rare to see when you have cohabitees purchasing property, but I have seen it in one of my cases, and it is best practice. Where you've got one cohabitee named as legal owners, but actually the beneficial interest is intended to be shared. An express declaration of trust should be entered into. Unfortunately, in the case where I saw it, the express declaration of trust was so poorly drafted, it actually created more problems than it solved. But a case where we have a separate document of an express declaration of trust was Young and Loretani from 2007. So that's an example of a court having to take in that into account that sort of declaration there. More commonly for cohabitees is that there is no express declaration of trust, and that's where we come into looking at common understandings, common agreements, that constructive trust element, and also proprietary estoppel. So what does it mean if you found your express declaration of trust? What can you take from that? Here we are. So 1978, we have the case of Pink and Lawrence. So the quote here is pretty firm about what this means. So it says, and this is a Court of Appeal decision, where there's an express declaration of trust, the doctrine of constructive trust cannot be referred to in order to contradict the expressly declared trust. The doctrine of constructive trust is one which applies in circumstances where there is no declared trust. Once a trust has been effectively declared, it can only be got rid of by either rescinding the document containing the declaration of trust on the ground of fraud or mistake, or rectifying it in the appropriate manner to vary or delete the declaration of trust. So that has to be right. I'd like to think that we all know that a trust isn't a document that is that easy to get out of. You can't simply decide you no longer want it to apply. They're usually irrevocable unless you can show one of these things to set it aside, and they're, mistake, fraud, that it's been obtained by undue influence, or you have to rectify it. Now, you'd think that would be really stating the obvious, but actually, I think it is often overlooked. And certainly with people that only are dipping their toe into Tolata work, I think you'd be surprised how often it's missed by lawyers. And I have seen solicitors argue, because I think everyone gets so excited about this concept of a constructive trust and of the parties dealing with the property in a particular way that may change the ownership of the property, that they actually forget that if there has been an express declaration of trust, that is an expression of the beneficial ownership for once and for all, unless you can show that one of these very, very narrow grounds of rescinding the trust has been made out. Pink and Lawrence, this was reiterated in Goodman and Gallant. Oh, I can't remember what the next slide is. Let's have a look. No, we're not quite stuck in down yet. So Goodman and Gallant is the case from 1986, and that really just reiterated what was said in Pink and Lawrence. So it said, if you haven't got your claim for rectification or your claim to rescind the trust, then your express declaration of trust conclusively defines the party's beneficial interests, and there is no room for the application of the doctrine of resulting, implied, or constructive trusts. So if you're on a case where you've got an express declaration of trust and the other side is trying to say, well, they've been living together for 20 years and so-and-so's been paying this and so-and-so's paid that, so actually the beneficial ownership is different, these are the cases you want to be relying upon. So the heading of my claim: can subsequent events vary what is agreed in the express declaration of trust? Well, you'd think the cases that I've just referred to are pretty conclusive on this. But unfortunately, in Stack and Dowden, which is the leading case for this jurisdiction in 2007, although it did approve Goodman and Gallant, some unfortunate wording in the judgment of Baroness Hale really opened a slight uncertainty about this point of law. So at paragraph 48 of that decision, Baroness Hale said that there's no doubt that a declaration, meaning an express declaration of trust, is conclusive unless later varied by agreement between the parties or by proprietary estoppel. So that unless later varied by agreement, I have seen solicitors and barristers try and rely on that to argue that there is scope that an express declaration of trust can be subsequently varied by conduct. Unfortunately, Baroness Hale didn't expand on what she meant by varied by agreement between the parties. She probably hadn't realised that wording would be so controversial. My understanding is it's widely accepted amongst lawyers, in my view, that what she meant was an express written variation. So essentially an express variation of the declaration of trust signed by all the beneficiaries involved in that declaration of trust. It would need to comply with the Law of Property Miscellaneous Provisions Act. Otherwise, you can't just change a trust willy-nilly. I think to read anything more into Baroness Hale's comments there is going too far, because otherwise a declaration of trust wouldn't be conclusive, and in any case, a party could just rely on subsequent conduct and verbal discussions to attack that express declaration of trust. However, we then have a rather frustrating decision in a case called Clark and Midas from 2010. So in this case, the claimant did try to make that argument that we've been discussing, that Baroness Hale's comments in Stack and Dowden meant that it was possible that subsequent conduct could vary an express declaration of trust, and so that constructive trust principles could still come into play, even though there's been an express declaration of trust. The defendant, and I think this is what I would do in this situation, sought to strike out the claim on the basis of that argument. And at the first instance, the master did so strike it out, being persuaded by all those authorities I've discussed, like Pink and Lawrence and Goodman Gallant. And the master said there that it had to be struck out because there was an express declaration of trust, and so a claim based on a constructive trust was not permissible. Claimant appealed, and the decision was set aside. I just realised I'd forgotten to do my slide. So there was an appeal, but the appeal was of the summary judgment / strikeout application. And the judge on appeal, which was Justice Warren, said the master did not give any consideration to the question of whether a constructive trust might have arisen as a result of matters which took place after the declaration of trust. And then says, in my view, rather bizarrely, nothing in Stack and Dowden or Goodman and Gallant can be read as suggesting that this is not possible. Now, I think it's stretching it to suggest that Goodman and Gallant doesn't say that that's not possible, because I think Goodman and Gallant is pretty clear on the point. So the appeal was successful, and that case management decision to strike out the claim was set aside. Now, we're left in slight limbo here, because we don't have a reported decision about what happened next. It probably settled. So all we have is a reported judgment of the appeal of the summary judgment application, which opens the door to an argument that constructive trust principles can still apply, despite there being an express declaration of trust, but hasn't actually decided that argument itself. My view is, you've probably guessed, is that it is unlikely that that argument would succeed after there has been an express declaration of trust. And I don't think that a court would find you could alter the shares of beneficial ownership if there has been an express declaration of trust. I think to do that would really just open the door far too widely to essentially setting aside trusts willy-nilly. There is a way that may help a claimant in this situation: proprietary estoppel. So that could be your get around if there's an express trust. So you can't rely on constructive trust principles. You may still be able to use proprietary estoppel. So as I'm sure we're all familiar, that is more based on not a court intervening when it considers that it would be unconscionable for a party to rely on its strict legal rights. So we have your promise, your assurance that the property is owned in a particular way, or that the claimant will give, the defendant will give the claimant a share in a particular property. We've got our detriment, we've got our reliance, and we've got our unconscionability. And then your proprietary estoppel claim might be the way to get around an express declaration of trust. Just can't remember. Just wanted to talk about one more case, which was quite interesting. A case called Hudson and Hathaway, which is quite a recent case from 2022. Now, this isn't proprietary estoppel argument, it's something slightly different. So in that case, there wasn't an express declaration of trust, but we have two cohabiting parties that started living together and acquire the house in their joint names, but there's no declaration of trust. Ultimately, the parties fell out and there was discussions about their financial arrangements. And the man sent emails to the woman in the relationship discussing the joint assets. And one of the emails said, essentially, you can have the house. You know what? I don't want any of the proceeds of sale of that either. Take it, buy yourself, sell it and buy yourself somewhere you can afford to live. And the email was subscribed with his name at the end. So just an email, just his name written at the end, Lee. And then there was another email as well, which said, under this arrangement, I have no interest whatsoever in the house, so while I'll continue to contribute, I won't do so forever. And again, that email was signed off with his name, Lee. So a rather novel argument was made that he had abandoned any interest in the house, not necessarily on the basis of constructive trust, but actually on the basis that this email complied with the statutory requirements to transfer land. So the argument was that Section 53 of the Law of Property Act 1925 applied, which says you can't dispose of an interest in land unless it's in writing and signed by the person who is selling the land. And equally, can't dispose of an equitable interest in land unless it is in writing and signed. And actually, that was found that the email was sufficient for that section. So just an interesting recent case that I wanted to talk about, because I think it highlights that sometimes less formal conversations could actually provide you with your winning argument. So keep an eye out for that. The other thing to notice, if you've got an express declaration of trust, is, yes, you may not be able to rely on constructive trust principles, but it doesn't mean that you can't rely on equitable accounting principles. So you've got an express declaration of trust. It doesn't necessarily mean, say the express declaration is its own 50-50, doesn't necessarily mean that when it's sold, you will get 50%, because equitable accounting is a separate doctrine, it operates separately and isn't about beneficial interests. My colleague Adam's going to talk more about equitable accounting after me. So that's something important to remember as well. Just because you can't use constructive trust, it doesn't mean that your client will be left out of pocket if you rely on equitable accounting. So looking briefly at orders for sale, I think the difficulty about advising, a lot of clients want to know, is the house going to be sold? Is it going to be sold from under my feet, or will I get my order? And it's quite difficult to advise about orders for sale because there aren't really many reported judgments about the exercise of the discretion. So the starting point is that if you're a beneficiary or a trustee of land, you can apply under Section 14 of Tolata for an order for sale. Now, Section 14 itself doesn't actually use the phrase order for sale. It says that the court can make any order relating to the exercise of the trustees of any of their functions, but it's well established that that includes an order for sale. So what a court will consider when looking at an order for sale are these things that are listed here on the slide. The intentions of the people who created the trust and the purposes of which the property subject to the trust is held. I often find there's quite a lot of overlap between those two. And again, without much precedent to help us about what they mean, in general, I largely approach those two the same. Welfare of any minor is often conclusive, and then the interests of any secured creditor. Often as well, a court will consider what the beneficiaries actually want to happen, and also the circumstances of the beneficiaries involved. Now, so these factors that are listed here are non-exhaustive, and there may be other relevant factors, and there is authority that the weight to be given to each of these factors in a particular case is a matter for the court's discretion. And that case for that's Mortgage Corporation against Share from 2001. So purposes of which the property subject to the trust is held, often you'll see here it argued, and I think this is really the principal case, that the purpose was to provide a family home for a couple or a family home for a family. It may also be that the purpose was to provide premises for a business, or that the property was held for the purposes of an investment. Obviously, you're more likely to get your order for sale in those situations. But where you've got your purpose is to provide a home for a family or a couple, often if that couple is broken up, you can make a good argument that that purpose has ended. If the party who no longer lives in the property is living elsewhere at a cost to them, often the fact that the property is still providing a home for just one of those parties won't be enough to prevent the court making an order for sale. The minors who occupy the property, this is often conclusive. If there are children occupying the property, usually it will be considered that the purpose of the property was to provide a family home, and just because the adults are no longer together, that purpose still exists. So an example of that is a case called Re Evers from 1980. Now that was a pre-Tolata case, as you'll appreciate, but still useful authority, especially where we have very little precedent about the application of Section 14. In that case, importantly, the male partner from the relationship had secure accommodation with his mother elsewhere, and the female partner from that relationship, who had custody of the children and was living in the property, was willing to take over the financial obligations of the property. And in that situation, no order for sale was made. but you can easily see that where the partner remaining in occupation is unable to solely finance the maintenance of the property, or where the partner who is no longer in occupation does not have security of accommodation, there very well may have well been a different outcome there. Other possibilities are a sort of hybrid type order. Case of Begum and Issa in 2014. So that's one of the few post-Tolata cases that we have, giving us some guidance about how orders for sale might be made where we have children living in the property. Our favourite, His Honour Judge Berens, did make an order for sale despite there being a minor child in the property who actually was also disabled. But there was a balancing act undertaken there between the interests of the co-owner that wasn't living in the property, and also that the minor was still relatively young, and it would mean that the co-owner would have been out of his interest, would be unable to liquidate his interest in the property for a time that was considered to be too long. So an order for sale was made, but postponed for 12 months in order to give the mother and child the opportunity to find somewhere else to live. And a similar postponement was done in the case of Edwards and Lloyd's Bank from 2004. So again, this is quite common, especially if the partner who's no longer living in the property does have security of accommodation. The property is only ordered to be sold when a child or children reach the age of 18 or finish their further education. But often a clause is included in those sorts of orders to allow the applicant to return to court if the circumstances change within that time. So there may be a review clause inserted into the order. In this order, there was a 5-year period at which point the court would reconsider an order if circumstances had changed. Another quite interesting case recently, let me just see if, is whether or not a court can order that one beneficiary sell or transfer their interest to the other. That was attempted in the case of Begum and Hafiz from 2015, where it's held that no, a court can't do that, but it may order that a property is sold and allow one of the beneficiaries the opportunity to purchase the property at a price to be determined by the court. I found this to be quite popular amongst clients when applying for orders for sale. And I think given this authority, it will probably be more readily ordered, although at the time it was quite a controversial decision. And then if the beneficiary doesn't take up the option of purchasing the property at market value or at the set price by the court, then the property will be sold on the open market. So I think that's also a useful one to have in your back pocket if you actually don't really want the property to be sold, if you want to hold on to it. And that's a Court of Appeal decision, so pretty strong authority. So that's worth asking for in certain situations. And thank you very much. That concludes my section of Law with Lunch, and I'll pass you over to Adam, who's going to talk about equitable accounting. Thank you.
Thank you, Anna. So I'm going to start off, hopefully, with the question, what is equitable accounting? It might be obvious to some or all of you, but the reason I start with this is to draw a distinction between the accounting exercise and the inquiry exercise, because it is important in my experience to draw a distinction between those things and to temper the relief that you are seeking accordingly. So in the context of co-ownership cases, equitable accounting is the event that follows the determination on liability. And I use the term liability loosely to refer to the parties' respective shares being fixed and any breach of trust arguments being resolved. And once that's been done, accounting is the exercise whereby payments made by the respective parties during their occupation of the property continuing after that are considered, and findings are made as to what credit or debits should flow from that evaluation. It was originally governed by the rules of equity, but has since been superseded by statute. And therefore, even though the outcomes don't often differ, I suppose there is an extra level of consideration in terms of the section 50 points that are up there on the screen. In most cohabitation cases, the exercise starts from when the parties have separated, albeit that is not an absolute rule. And it's commonly dealt with in a somewhat rough and ready fashion at the conclusion of a trial, albeit may not be necessary if the court has taken into account the parties' entire course of dealings when quantifying their respective shares. And that comes from a case of Jones and Kerner that you might be familiar with. Having a rough idea about what equitable accounting is, I turn to ask the question, what is an inquiry? And I do so by referring to a familiar expression that we've all seen on pleadings, and it's a plea for all necessary accounts and inquiries. And often it's on a statement of case, but unfortunately without a great deal of thought being given as to how it will affect the mechanics of proceedings. And they are in fact two different forms of relief. That is to say, an account is one form of relief and an inquiry is a different form. And in the context of domestic cohabitation cases, it's quite often only necessary and indeed proportionate to plead an account. And the distinction is as follows. An account is only possible where the court is able to identify the nature and extent of the compensation due to the respective parties. And as we'll come on to see, the heads of compensation are commonly pleaded, quantified, and hopefully evidenced by the time the trial rolls around. On the other hand, an inquiry will only be ordered where the court is satisfied, usually after trial, albeit there's no reason it can't be directed at a case management conference, that something is due to the claimant, but the evidence available does not lend itself to assessing the amount. So an invitation to conduct an inquiry is, in essence, an invitation for a further round of litigation. So on that point, my experience is that you would ask for an inquiry in a more complicated case. So say one of my recent cases where I had two brothers and they had bought a number of properties over the years. Those properties had been leased. It was a mixture of commercial and residential properties. And after a few years, the two brothers fell out. And the properties, they were never formally split. Some were used by one brother, some were used by the other. Some had tenants, some were left to go into ruin. And in order to properly undertake the exercise of doing an account, it was necessary to have a full trial trying to get to the bottom of what credits and what debits were due in respect of each property on the roster. And that's not something that you were going to get through within the confines of the trial liability, not without stretching the timetable into probably 2 to 3 weeks. By comparison, the domestic cases, if I can put it that way, where you've got one property, a couple are a family, there's been a separation, one of the partners has moved out, it's actually very easy to get your ducks in a row before you issue And on that front, it makes a world of sense to quantify losses. Again, I use that term loosely, but to quantify losses, evidence losses, and have them laid before the court without the need to go into that inquiry at a later stage. So with that in mind, I'll turn to the first head of an equitable account, and that is occupation rent. Now, the common law requires proof that a party has been ousted from a property before an order for occupation rent will be due. Equity is more flexible and will allow for occupation rent where it is necessary to do broad justice between the parties. And in fact, broader still are those Section 15 requirements that you saw on the earlier slide. In reality and in practice, occupation rent is likely to be ordered, subject of course to it being set off against any interest payments for the mortgage, if the co-owner could occupy, chooses not to. As to quantification and evidence that would need to be supportive of a claim for occupation rent, there are two options in my experience, and they're largely going to be driven by proportionality and tempered by the prospect of actually recovering occupation rent. And this is something that Anna and I were discussing before the talk. And our experience is that actually occupation rent is quite often an afterthought in trials, and it's rare to see an order for it unless there are circumstances that are quite unique to a particular case. So as to the options, option one would be expert valuation evidence, and often that can be tied in with a valuation for the purposes of setting a minimum sale price for any order for sale and for assessing renovations. Or option two would be anecdotal evidence, and that would be Rightmove, Zoopla, and effectively what we're doing is looking for a like-for-like property in the area to try and extrapolate a rental value that we can properly put before the court. Deciding between the two is really a matter of personal judgment, weighing in the balance the costs associated with incorporating potentially contentious expert evidence into proceedings, as against the value it will potentially add to any relief granted. Now, before I move on to mortgage repayment, I think a slight slip of the tongue earlier and the point about when occupation rent will be due. My experience in proceedings that I have dealt with is that if a party has been excluded from the property, it will at least in principle be recoverable. The circumstances where it's highly unlikely that it would be recoverable are where the party that is apparently ousted could return if they were so minded. Of course, there needs to be evidence that they could return, and they choose not to. If they could return and choose not to, it's not likely that they would recover occupation rent. So going on to mortgage repayments, before actually looking at who is paying the mortgage and why, it's important to understand what agreement, if any, the parties initially arrived at before the relationship broke down. For example, the parties may have agreed that one of them would be solely responsible for the mortgage, say because the other had provided a large deposit. If the payer ceases to pay in breach of that agreement, they may have their share debited with the amount that's outstanding. If, however, they continue to pay, i.e. they continue to fulfill that agreement after the other party has moved out, then it's unlikely that they would be able to seek their share to be credited with an amount equal to the other side's hypothetical share. Nor could they hope to set off interest payments against the other party's occupation rent insofar as it's due. And that's important to remember whenever we're going down the accounting exercise, is always to have in mind what agreement, if any, did these parties actually enter into, and has there been a breach of the agreement? Quite often, taking detailed instructions will be the difference between running a point that will win and running a point that is destined to fail. Most commonly, what we see is a party leaves the property, ceases to pay their share of the mortgage, and the party remaining in occupation pays the entirety. In those circumstances, the paying party will, at least in principle, be entitled to credit in respect of those payments. For convenience, and this is in order to avoid an inquiry and the costs associated with an inquiry, it's quite often the case that the interest element of any repayments is treated as being equivalent to and offset against any occupation rent that the individual in occupation might otherwise be ordered to pay the other party. If we do get to the point where there is no occupation rent due and there is a repayment style mortgage, in order to quantify the amount due, it does become necessary to identify what constitutes capital repayment and what constitutes interest. And of course, we'll need bank statements in order to do that. And sometimes banks will be willing to provide a statement that draws a distinction between capital repayment and interest repayment. Moving on then to improvements and repairs. Co-owners cannot usually carry out improvements or repairs and charge the other co-owner for that work. If, however, the work improves the value of the property, the paying party will be able to recover, at least in principle and subject to any contrary intentions, they'll be able to recover the lesser of their expenditure or the capital appreciation. In terms of evidence, naturally, if you're going to be putting before the court an increased value, that is opinion evidence, and it will need to be substantiated by compliant expert evidence. Before you get to the point where you are instructing expensive expert reports, it is sensible to do some due diligence. And usually that can be as simple as asking clients to go to 3 estate agents, getting them to provide a valuation, which of course you'll need if you're asking for an order for sale, but including within that valuation an indication as to what value, if any, certain renovations have had on the property. In terms of, and you'll see at the top of the slide there, mere repair or value enhancing renovation, it's very rare that anything like redecorating or carrying out repairs will add value, unless of course it's a dilapidated property. And usually one wouldn't expect to see a claim for improvements unless there was something quite substantial, for example, an extension of some elements of conversion to the property. Finally, before we go to any questions, I've got a slide here for rents and profits. This aspect of accounting is most closely allied to traditional trust work, and that it derives from the trustee's general accountability for profits. And it follows from that the party receiving the rents or the profits, whilst they are liable to account for them in equity, may be able to recover an allowance for effort and expense. In those circumstances, there will be evidential considerations if you are either making a claim of this nature or defending one. But it is a claim that can be maintained irrespective of whether or not an order for sale is made, because it is effectively treated as money on the hands of a trustee, which ought to be dispersed to beneficiaries. It's slightly more tricky than the other heads that we've talked about, because usually the individual seeking to recover those monies won't always be privy to how much is being paid, when it's being paid, and who it's being paid by. So if this is being considered, my view would be that a very early view has to be taken as to tactics, and that is to say, reaching out to tenants where possible, pre-action correspondence to try and elicit favourable evidence or any evidence, pre-action disclosure applications, and in particular having a very good eye on disclosure obligations and making specific disclosure applications during the commencement of proceedings. And with that ends the whistle-stop tour through equitable accounting. Thank you very much for attending today and listening to the two of us. It's been a pleasure to have such a easy and uninterrupted talk.
No heckling today.
No heckling today. I'm not used to that. Usually I've got a judge tripping me up every 5 minutes. But if anyone does have any questions, feel free to stick around. Anna and I are probably going to be here for at least another 5 or 10 minutes. Put a question in the box, pop on the screen, come and say hello. If you don't already, link up with us on LinkedIn. I can't profess that I post too much useful commentary, but I do usually respond to in messages. And if something's interesting, I will give it the occasional like. But with that, I think we're about there.
Yeah, and all the events that we do like this will be posted on LinkedIn by our clerks, who are paid to keep up with marketing, whereas it's something that we always have to put extra effort into. So it's always worth following Chambers as a whole as well. And again, just reiterating Adam's thanks for listening.